Hi, I just would like to draw your attention to a very, very important and practical, important constitutional court judgment. It will be called in the future the Tereza Rayment judgment, and it was handed down on the 4th of December, so rather recently, and it's really, really important for every foreigner who has a South African child and is a temporary residence holder. Okay, so if you are a permanent residence holder, it's not applicable to you. And if you don't have a South African child, then you also don't have to watch this video. For all the other ones, it's really important to know. So there are some fundamental changes. The Constitutional Court handed down the judgment, which basically confirmed, which was already shared by the High Court before. And I just want to break down this lengthy summary or judgment into really three core messages, okay? So what has changed and for whom is it really important? So I think number one, if you're in a life partnership with a South African citizen or permanent residence holder and have a South African child, this is really important for you in case your relationship has ended, okay? So in the past, there were lots of problems connected to it, but basically now what it means now is that if your life partnership has ended, then you do not have to automatically leave the country because your visa became invalid. That has been stopped and explicitly said that the visa, the 11.6 you are on, will be still valid for 3 months, and you have 3 months to then change your status, okay, to another one. And because you have a child and you care for the child, which is the second requirement, so just having the child is not actually a requirement, there is a second compulsory element that you're meeting your parental requirements, whatever that means, but I think an active parent knows what it means. Then you actually have 3 months to change to a relative's visa, and you can do this from within South Africa. So very explicitly, you can change your status while you're on a visitor visa, which normally is not allowed. You can change the status in South Africa to apply for a relative's visa in terms of section 18.2 once your relationship has ended, okay? So that's really important and really, really practical important. You can also continue doing your business or continuing working. And I think the second important change is now applicable to the relatives visa. So you forget the life partnership, we moved on, you are in South Africa based on your South African child. And so far, it was very clear that you're not allowed to work on a relative's visa. Okay, that has changed. So it's very clear now, if you're in South Africa on a relative's visa, based on your South African child, minor child, and you are a caring parent and meeting your parental responsibilities, then you are now allowed to work. So the Constitutional Court actually said that the legislator has 2 years to change the legislation. However, in the meantime, for these 2 years, it suggested, or actually it wrote down new wording of certain sections of the Act and the immigration regulations. And it's aimed at sections 10.6, 11.6, 18.2, which is relative, and then the regulation 9 or something, which is the exception to the rule that you cannot change your status from a visitor visa. So very, very good news. So in summary, please, so the ending of your relationship with a South African spouse or life partner does not mean automatically you have to stop working and leave the country. If you have a South African child and you're caring for the child, you can then change to a relative's visa, and you are allowed to work now on a relative's visa. So this is really good news. And I hope this was useful. Bye-bye.